or the persons of interest had any delay in this matter, my lady, we just want to place on record that especially Mr. de Kock, as soon as he received the summons, attempted his utmost best to get legal representation and funding as soon as possible. I mean, we instituted no less than 3 urgent applications, and luckily Mr. Notley from the local state attorneys greatly assisted in that regard. So just to place on record that there's no delaying tactics from any of the parties here. We attempted our best to get the legal representation as soon as possible. And with regarding the evidence being restricted.
Just remind me what the position is at present, Mr. Schoolman, regarding legal representation from State Court.
We were provided with legal representation, I also believe about a week and a half ago. And this is where I just want to address the courts on the allegation or the statement that evidence will be given with restriction. Now, I don't think it's any of the persons of interest to say that we want to restrict any evidence. The fact of the matter is, merely weeks ago, we received thousands and thousands of pages. I believe it's more than 9,000 pages. So there's no intention to restrict any of the evidence. It's just that we won't be able to sensibly participate in these proceedings if we haven't even had the opportunity to go through the bundles that has been presented. So we just need the opportunity to go through everything to participate in this matter. But based on the instructions from client is that we will provide our full cooperation and hopefully help and assist to answer any questions. But I agree with the sentiments and statements by my learned colleagues that until we had the opportunity to at least go through all the documentation, that no evidence can be presented that implicates the client, as it pleases the court.
We have no objection to the inspection in local being held. It's the 2 suggested places, as well as the meeting of those witnesses will not be implicated.
None, my lady. That's it.
Thank you, Mr. Schoolman. Anyone else?
Melody, if there are no other parties to make submissions, could I have an opportunity to respond to some of the points made by my learned colleagues?
Let's see if Mr. Coltman has anything to say.
Lady, your ladyship will recall that I did not attend or could not attend the case management meeting of the 19th of May this year. But I have been advised by my colleague, Mr. Governor, who attended it. I mean, I understand, having read the minutes of that meeting as well, that there had been an agreement. And I beg your pardon, in fact, your ladyship had made a ruling supporting the request that had been made by Mr. Varney, that evidence be led by the family witnesses regarding evidence that's it appears in publicly available documents. And I'm sure Mr. Varney will put it much better than I'm putting it. And all these objections that are now raised was never raised at that meeting.
Yes, but the argument has always been that evidence that does not implicate the person of interest will be introduced until such time that they are
that was the
benefits of legal representation.
Indeed, and that was I think the general principle, except for the qualification made to that submission by Mr. Varney, and which ruling your ladyship had made in that regard. So that's the first point. And I'm not going to expand on that, but I just wanted to also point out number 2, regarding this issue about evidence it's not available yet, etc., etc. Your ladyship will also recall, and I'm sure my learned friends will agree with me, that it had been stated on several occasions by the members representing the persons of interest that they would not read any document until the issue of legal representation had been resolved. So whether the documentation is available or not, they were not going to read it in any event. So that needs to be made clear. And just with regard to the issue, the last statements or submissions made by Mr. Skuma and my learned friend Mr. Skuma in respect of the vast amounts of documentation. We will have a pre-trial. It has been agreed that we have a pre-trial meeting after the opening addresses, so that we can resolve all these issues regarding the record, documentation, etc. But I just want to point out that the record had been furnished, the first part, that is the beer inquest record in regard to the beer inquest, and whether there may be outstanding or missing documents, the issue can be resolved, including the complete Zitzman record, had been provided to Mr. Vasaki, I think during July last year, to all the legal representatives, in fact. And I can go and look for the exact date if necessary. With regard to the TRC evidence, it was also, I remember my previous colleague, Ms. Bosman, she sent these documentations to everybody. And I remember that at one stage she sent links to where these documents in respect of the TRC evidence could be downloaded or
I don't think we should go there, Mr. President,
yes,
because there's also the issue of parties complaining that they had not had funding for legal representation, and therefore it will be difficult for them to...
Then let me leave it at that.
Anyone who's begging to reply, although...
If I may seek your indulgence,
yes.
It appears that my colleagues are seeking a ruling from you in respect of what is it the family members may say and may not say. And it appears that my learned friends representing the persons of interest simply don't want any references to them made, or certainly no view is expressed about the role they play arising from the documents. Milady, as Mr. Coltman has submitted to you, we would also urge you to stick with the ruling that you made in that case manager meeting, that the family members would be free to make reference to publicly available documents, namely the 2 inquest records and findings, and the TRC proceedings and the findings arising from the work of the Truth and Reconciliation Commission. Because, milady, if that ruling is abandoned, we have a fear that this inquest, at least the first part of this inquest, could turn into something of a farce. And the reason I say that, milady, is because we are then expected, the family members, are then expected to pretend that that information that is publicly available, those 2 inquest records and the findings and the Truth Commission records, that they simply don't exist and that they must be ignored. And milady, that would turn these proceedings into a farce and into a pretense. And I don't believe that this court would wish to go down that road. Milady, our clients are the wives of the Cradock 4. They were not on the scene. They were at home. Our clients are the children. They weren't on the scene either, and they were mostly young. Some 2 or 3, some hadn't even been born. So clearly they're not in a position to engage in any direct implication. But to suggest that they must pretend that the De Beer inquest and the Zietsman inquest and the findings arising from them, as well as the proceedings before the Truth Commission, And the amnesty proceedings would, with respect, turn this proceeding into a pretense which would be the subject of much ridicule. Lady, this is an inquisitorial process. It's an inquiry that you are in charge of. Yes, indeed, you have to respect procedural fairness. But such considerations should not stop the family members testifying about what they know, about their perspectives on hearing about the findings emerging from the Zitzman inquest and their views of what happened in the Truth Commission. We would simply urge you to stick to your guns on that matter. We will also take the extra effort of providing references to the particular documents or findings that are referred to. As Mr. Coltman has said, these have been provided many months back, in some cases years back. Although we don't have a full paginated record, which will make it a little more difficult to make reference to the documents, we will nonetheless try. And as mentioned, if we have a pre-trial conference this afternoon, maybe those issues can be resolved. Those are the submissions.
Thank you. Mr. Ngoroichobi, your position is somewhat different to the one alluded to by Mr. Van, in that the witness you will seek to call will do more than refer to public documents.
Yes, my lady, he will. He is in a slightly different position because on some of the events he's an eyewitness, personally there. But he also does have references to publicly available material. My problem is I'm unable to call him for part and not to call him for everything because I have to recall him anyway when he is being prosecuted. And it seems that I should either have the right to call him, and then the consequences for our learned colleagues will deal with those, or then I tell him that he must come on a future date. Those seem to be the stark options. I cannot say that he can be called for part and not for the balance. I've just gone through the statements that Mr. Biden's clients submitted. The bulk of those statements actually don't even mention the names, particularly the statements of the leaders. It's the statement of Mr. Lukali Talata that's lengthier and meatier and provides actual names, but not from his personal knowledge, but from what he has read. But this needs to be clarified now, because what is going to happen is that he will testify, and then 5 minutes into his evidence there will be an objection. And they will say, no, he is implicating us. But I want to object because it's hearsay evidence. That makes the proceedings even more of a fuss.
Are you referring to Mr. Kolata?
Yes, I'm talking about Mr. Kolata. I'm saying if he can testify and implicate in this way, I don't understand why my client cannot testify and also implicate people in this way. But he's got personal knowledge, he wants to testify, he's ready. The issue we have now is our learned friends, those ex-members of the police force have got the money. The issue now is we got the money too late, so we need more time to prepare. That's really their issue. The defense force, I understand, the department has decided not to give them the funding. But I'm saying that should not stop in the way of the inquest. The inquest must proceed. They must continue with a parallel fight with the department. But I would like also to call my witness, but on the express understanding that he will implicate General Van der Verseyze. I don't want to pretend about that he won't. He will.
Do you have other witnesses that you will be calling apart from?
Yes, yes. But the one I'm clearer now about is this particular witness. I still have to take instructions on the others. But I can't commit on those.
Lady, I just want to put it on record. It's not our approach that a witness should not be allowed to say what the witness wants to say. That we totally support, but just at the appropriate time.
I think I'm in a position to make a ruling on this aspect. and that as agreed upon previously, and the ruling made in that regard, that the inquest should proceed as it has done today, as was scheduled, and that only those witnesses will not be implicating the persons of interest, especially those that, especially the one in particular who has not received legal funding or fund for legal representation should not be led, but that should be done at a later stage. So that is the ruling that I am making, that the inquest should proceed as planned, and that only those witnesses who will not be indicating those concerned should be led, and that includes witnesses who will testify based on the publicly available documents. Those can testify.
There's a copy.
And in the next thing now,
Lady, so just so we're crystal clear, does your ruling say that family members may not refer to publicly available documents? So they are able to? I beg your pardon, lady.
and shall we agree or discuss now what time we, or can we do that at a later stage, or can you come and see me in chambers with the suggestion as to when we should meet?
Sorry, Lady, I think it would be more appropriate for us to take the agenda and we can meet in chambers so we can discuss the inspection in law.
You can flesh it out amongst yourselves in the meantime, and then we can come and
Yes, ma'am. That would be it.
Innocent.